Most people walk into a lawyer's office believing they're about to find an ally, a champion, someone who will stand between them and a system that feels impossible to navigate alone. And that's exactly what the polished waiting rooms and framed certificates are designed to make you feel. But the moment that consultation ends, there's something most lawyers will never tell you. Not because they're dishonest, but because the entire profession depends on you not understanding it. Here's the uncomfortable truth: the legal system is not primarily built to deliver justice, it's built to resolve disputes. And resolution, in legal terms, almost always means compromise. That single word reshapes everything you think you know about your rights. So here's the question that should keep you up at night: how much of your case's value disappears before it ever reaches a courtroom? And what don't they want you to understand about the machinery running behind your back? Over the next few minutes, we're pulling back the curtain on the silent rules of law that can make or break a case, the hidden incentives, the psychological architecture, and one specific, centuries old legal doctrine that can destroy an otherwise winning lawsuit in an instant. Most people have never even heard its name. We'll get to that. But first, you need to understand the economic reality that shapes nearly every piece of legal advice you'll ever receive. Imagine you've just been seriously injured in a car accident. The other driver was clearly at fault. You hire a lawyer on a contingency fee. It feels like a partnership. In reality, you've just entered a business arrangement where your lawyer is making a calculated bet on your suffering, and their math is not your math. A law firm is a business. It measures risk, cash flow, and return on investment. A trial might take 3 years and cost $100,000 to prepare. A settlement can be negotiated in months with a fraction of that overhead. So the question becomes, does your lawyer's financial incentive truly align with maximum compensation for you or with maximum efficiency for the firm? Almost nobody talks about this part, but it's the gravitational force behind the vast majority of outcomes. Lawyers rarely say, it's in my economic interest to settle quickly. Instead, you'll hear, trials are unpredictable, or a settlement gives you certainty. And none of that is false, but it's also not the full picture. The full picture includes something known in the legal world as the repeat player advantage. Insurance companies and large corporations litigate thousands of cases a year. They know the judges. They know the local rules. They can afford to lose occasionally because their risk is spread across a portfolio of cases. You, on the other hand, only get one shot. You are a one-time player in a game designed by and for repeat players. And that imbalance is the quiet engine, humming beneath every claim. Now, let's introduce the first open loop. I mentioned a legal doctrine that can vaporize a perfectly good case before it ever reaches a jury. It's not hidden in some secret legal text. It's taught in the first year of law school. Yet, when clients sit across from their attorneys, it's almost never explained in plain language. In a handful of American states, if you are found to be even 1% at fault for your own injury, you recover nothing. Zero. Not a reduced amount. Nothing. This isn't a myth. It's a real operating principle of law called pure contributory negligence. We'll reveal exactly where it still applies and why it survives later. But here's where it gets strange. Even outside those extreme jurisdictions, the law has developed subtle ways to lower the value of your pain. One of the most powerful is the language itself. Legal language is not designed to clarify. It's a closed system. When a lawyer uses terms like proximate cause, duty of care, or mitigation of damages, they're not just using jargon. They're operating inside a framework that most clients never fully penetrate. And that knowledge gap is expensive. Every hour you spend not understanding the procedural clock ticking against you is an hour the other side can exploit. And then something unexpected happens once litigation actually begins. Discovery, the process where both sides exchange evidence. On television, discovery is a dramatic reveal of a smoking gun. In reality, it's a war of attrition. The party with more resources can bury the other side in documents, schedule depositions at inconvenient times, and file motion after motion to drain your finances and your willpower. Your lawyer knows this. They've seen good cases crumble not because the facts were weak, but because the client simply ran out of emotional or financial oxygen. But telling you that up front might scare you away from pursuing a legitimate claim. So the silence remains. Let's pause for a moment. think about your own experiences. Have you ever signed a contract, clicked agree on terms and conditions, or dealt with an insurance adjuster after an accident? How much of that interaction was you genuinely understanding your rights versus simply trusting the process? That gap between trust and understanding is exactly where the legal profession thrives. Now, let's move to the midpoint escalation. In the United Kingdom, the game changes dramatically because of one three-word phrase: loser pays. In most American jurisdictions, each side bears its own legal costs regardless of who wins. That rule was created to encourage access to justice. But in the UK, the losing party typically pays the winner's legal fees. This completely transforms the risk calculation. It means the cost of being wrong can be financially catastrophic. British lawyers know this, and while they may mention it, they don't always emphasize the psychological weight it places on a client's decision making. The fear of losing can force people into settlements far below the true value of their claim. And fear, as it turns out, is one of the most profitable emotions in the legal industry. Yet here's what changes everything. Neither system is really about truth. Litigation is a storytelling competition. Two sides construct narratives from the same set of facts. The winner isn't necessarily the one who is right. The winner is the one whose story feels more coherent to a judge or jury. And that narrative control begins the moment you give your first statement. Words like, "I'm fine after an accident," can become weapons used against you later. But how many lawyers train their clients on the power of those first 60 seconds? Very few. The damage is often done before the retainer is even signed. So let's close the loop we opened earlier. Pure contributory negligence. It remains the law today in Alabama, Maryland, North Carolina, Virginia, and the District of Columbia. If you are hurt in one of these places and the other side can convince a jury you bore even a sliver of responsibility, say you glanced at your phone a second before the crash, or you walked a little too quickly on a wet floor, your entire claim can disappear. Lawyers in those states know this, but they often frame it gently because they don't want to extinguish your hope before they've even filed the paperwork. The secret isn't malicious, it's strategic. And that's the real lesson. We end where we began. The profession isn't lying to you, it's just not telling you the whole story. Justice is not a guarantee, it's a product. And like any product, its quality, speed, and price depend on a system of incentives that operates long before you ever walk through the door. The question worth reflecting on now is this: knowing what you know now, how differently would you approach a legal problem tomorrow? I'd genuinely like to hear your thoughts in the comments. If you've encountered a moment where you felt the legal system wasn't being fully transparent, share that. Let's pull the conversation into the light. If this kind of investigation into the hidden machinery of law is something you find valuable, consider subscribing. I uncover the patterns that most professionals prefer to keep invisible. No clickbait, just the architecture of power, explained.